Hello and welcome to another session on Lok Adalats. At first, let us look at advantages of Lok Adalats. Speedy justice and saving time from the lengthy court procedures. Lok Adalats ensure speedy justice because it can be conducted at suitable places, arranged very fast in local languages too, even for the illiterates. The procedural laws and the Evidence Act are not strictly followed while assessing the merits of the claim by Lok Adalats. Hence, Lok Adalats are also known as people's festivals of justice. The victims and the offender may be represented by their advocates, or they can interact with the Lok Adalat judge directly and explain their stand in the dispute and the reasons thereof, which is not possible in a regular court of law. Justice at no cost. Abraham Lincoln has observed, discourage litigation, persuade your neighbors to compromise wherever you can. Point out to them how the nominal winner is often a real loser in fees, expenses and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. Lok Adalat is only institutionalized mechanism of dispute resolution in which the parties do not have to bear any expenses. There is no court fee in Lok Adalat. If the case is already filed in the regular court, the fee paid is refunded in the manner provided under the Court Fee Act if the dispute is settled at Lok Adalat. The kind of refund is an incentive given to parties to negotiate for settlement. Lok Adalat is a boon to the litigant public where they can get their disputes settled fast and free of cost. Denial of free legal services to the poor accused persons or under trial prisoners would vitiate the principle of reasonable, just and fair procedure, which is implied in the right to life and personal liberty under Article 21 of the Constitution. In Sukhdak vs. Union Territory of Arunachal Pradesh, the apex court held that failure to provide free legal aid to an accused at the state cost would vitiate the trial. The court has set aside the conviction of an accused on the ground that he was not provided with legal aid at the time of his trial, and thus there was violation of Article 21 of the Constitution. Solving problems of backlog cases. Delivering the inaugural address at a seminar on judicial reforms, the President said, delays render the commencement's knock on the temple of justice a frustrating experience. Litigants are not able to lead normal lives, being unsure of the verdict in their case. Terming the pending cases as an explosion of litigation, she said the current figures reveal that the arrears in high courts exceeded 40 lakh cases and in subordinate courts 270 lakh. The curse of backlogs in India is well known, and Andhra Pradesh High Court Judge Justice V.V. Rao has gone to say that it will take 320 years for the Indian judiciary to clear its backlog. In a Lok Adalat, if a compromise is reached, an award is made and is binding on the parties. It is enforced as a decree of civil court. An important aspect is that the award is final and cannot be appealed, not even under Article 226, because it is a judgment by consent. All proceedings of Lok Adalat are deemed to be judicial proceedings, and every Lok Adalat is deemed to be a civil court. Section 25 of the Legal Services Authorities Act 1987 provides that the provisions of the Act have an overriding effect, notwithstanding anything which is inconsistent with any other law. In Punjab National Bank vs. Lakshmi Chand Roy, an appeal was filed under Section 96 of the Code of Civil Procedure against the award made by Lok Adalat. The question before the court was whether such an appeal is maintainable. So, in this case it was reiterated that an appeal would not lie under the provisions of Section 96 CPC. Lok Adalat is conducted under an independent enactment, and once the award is made by Lok Adalat, the right of appeal shall be governed by the Legal Services Authority Act. It has been specifically mentioned in Section 21 subsection 2 that no appeal shall lie against an order of Lok Adalat. Further, In Board of Trustees of the Port of Visakhapatnam versus Presiding Officer, Permanent Lok Adalat cum Secretary, District Legal Services Authority, Visakhapatnam and another, it was observed that the award is enforceable as a decree and it is final. The endeavour is only to see that the disputes are narrowed down and make the final settlement, so that the parties are not again driven to further litigation or any dispute. The scheme also helps the overburdened courts to alleviate the burden of arrears of cases, and as the award becomes final and binding on both the parties, no appeal is filed in appellate court, and as such the burden of the appellate court in a hierarchy is also reduced. Hence, to alleviate the accumulation of cases, the Lok Adalat is the need of the day. Next point is maintenance of cordial relations between the parties. The main thrust of Lok Adalat is on compromise. When no compromise is reached, the matter goes back to the court. While conducting the proceedings, a Lok Adalat acts as a conciliator and not as an arbitrator. Its role is to persuade the parties to hit upon a solution and help the reconciling the contesting differences. Lok Adalat cannot decide the issues, nor can it influence or force the parties to decide in a particular way. It encourages consensual arrangements. It is not possible for Lok Adalat to decide upon any issue not acceptable to any of the parties. Lok Adalats are also required to follow the principles of natural justice and other legal principles. In Krishna Rao versus Bidar District Legal Service Authority, the question raised was whether the Lok Adalat could pass a decree when all the parties had not appeared before the Lok Adalat nor had notice been issued to them. The Karnataka High Court interpreted section 20 subsection 3 of the Legal Services Authorities Act to hold that all the parties to the suit must be present if the compromise was to be a valid one. Thus, the impugned decree was struck down as being a nullity by reason of violation of natural justice. In Lok Adalats, disputes are not only settled, but also cordial relations between the parties are retained as disputes are resolved amicably. Hence, it is a very healthy way of dispute resolution. In conclusion, we can say Lok Adalats, as it has been again and again reiterated throughout the discussion, serve very crucial functions in a country due to many factors like pending cases, illiteracy, etc. The Lok Adalat was historic necessity in a country like India, where illiteracy dominated about all aspects of governance. The most desired function of Lok Adalats may seem to be clearing the backlog. With the latest report showing 3 crores pending cases in Indian courts, but the other functions cannot be ignored. The concept of Lok Adalat has been a success in practice. Lok Adalats play a very important role to advance and strengthen equal access to justice, the heart of the Constitution of India, a reality. This Indian contribution to world ADR jurisprudence needs to be taken a full advantage of. Maximum number of Lok Adalats needs to be organized to achieve the Gandhian principle of Gram Swaraj and access to justice for all. With this, I would like to conclude this session on Lok Adalats. Hope to see you soon. Thank you.